be open, and every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law and right and justice administered without sale, denial, or delay. And Section 8, printing presses shall be free to every person who undertakes to examine the proceedings of the General Assembly or any branch of government. No law shall ever be made to restrain the right thereof. Every person may freely and fully speak, write, and print on any subject, being responsible for the abuse of that liberty. And when you read the open records laws and open meetings laws, they really are very well-written laws. They're very specific. They tell the Attorney General what to do so he doesn't have to try to figure it out. And as long as he does what the laws say, he's going to be doing the right thing, and things are going to be working the way they should. Now, there's a couple of little wrinkles that have come in lately that might interest you, like the terrorism exception, but I guess we'll work through that. But at any rate, I'm glad to be here and look forward to participating further. Thank you.
Mr. Larson.
I'm real humbled to be in front of you today. I guess I'm the candidate for more secrecy in government. I represent disadvantaged people every day. And what this is we're discussing today your freedom of press, but it's also discussing a balancing of interest. There are people who might get hurt, and I talk to these people daily. I represent people in criminal courts who don't want their situations, their family situations revealed. It's a problem, and all these specific exemptions to the open records and open meetings have reasons, and I'll discuss them with you, but that's not what I do. I'm here because I promised to myself when I filed for this candidacy that I'd go anywhere and any place. Well, I'm the only candidate here who does not do civil practice, or has not done civil practice. It's not what I do, but I can't talk about the issue I'm most interested in, of reducing the cost of government, the prices that we pay. But what I am interested in is having you see both sides of the issues. That's what lawyers do. Thank you.
Thank you. Now to the questions, and the first question will go first for an answer in rotation to the Republican candidate, starting with Mr. Kimball. So just a heads up. The first question: the Attorney General's office has an important role under Kentucky's law in ensuring public access to government records and meetings, and it has performed those duties pretty aggressively, at least under the past two Attorneys General. As Attorney General yourself, what priority would you put on making government operations open to public scrutiny? Do you see the office's role changing if you are elected to this office? Mr. Kimball.
I'm first.
You're first.
Oh. Well, I would be very aggressive in enforcing open records law. It's very plain, like I said. One thing that I would like to pursue is I don't want to be shy as Attorney General about proposing legislation. And I think our juvenile proceedings, paternity, termination of parental rights, and so forth should be open, and they aren't. And so I would propose legislation to open those proceedings up with protections for the privacy of the individual litigants, which is not that difficult. I think you've been reading a lot in the paper about the problems we have because a lot of these processes are secret. I won't say the kids are being taken away in the night by state workers, but sometimes you wonder if maybe that's not happening. So that'd be one thing that I would emphasize.
Mr. Larson.
I'm sorry, it sounds like, I don't want to use the word bull. It sounds like unusual conversation, saying little or nothing and just asking for your favor. What I want to say is that Attorney General, I don't anticipate as a legislator. This is a separation of powers issue. The Attorney General doesn't legislate, or at least that's not his primary role. He's a chief law enforcement officer of the state, and his job is to prosecute cases criminally. And maybe this is just a tangent issue to The role of review has been set by the statute. I don't disagree with the statute, but I might take a look at that. Might take a look and see whether the Attorney General is the proper place to do that. After all, there is a conflict situation at times that the Attorney General has to get into. What I would emphasize, emphasize something else. Thank you.
Mr. Coleman.
Well, I think you discussed the aggressive nature of the past attorney generals, and I would agree that given the statutory mandates with regard to dates that require responses through the attorney general's office, that it needs to be aggressive in order to meet those statutory mandates. I think one problem that I had, and if there is a answer to that since I've been county attorney, is that because the attorney general is the one who makes decisions with regard to open records, the county attorneys didn't really have a resource to go to say, I've got this request, how do I handle this? And I assume that's somewhat the same with the agencies. So I think that there needs to be some resource out there in order to make those decisions locally, because a lot of the requests that come to the attorney generals is not because someone's trying to hide the ball or to try to hold back documents they're not supposed to. It's just because that there are so many different exceptions, and how those exceptions apply are a little tough sometimes to make a quick decision on, and you've only got 3 days in order to respond. So I think if we had a resource, whether it's a part of the Attorney General's office or separately, that those decisions could go to, I think it would not only speed the access to records, but also make the process much better for everyone.
Mr. Conway.
Yes, I would continue to be an aggressive enforcement advocate for open records and open meetings, much like the last two attorney generals have been. One of the reasons that the statute is very specific, that you can appeal to the Office of the Attorney General and get an answer from the Office of the Attorney General within 10 or 20 days, is the expedience factor. You can't always get that quick turnaround from the court system, and so it's important that the AG is not only an effective advocate, but is also an expedient advocate for open records and open meetings. Secondly, I would say that as Attorney General, I would follow what the statutory mandates say, and that is that the presumption is that meetings are held in open air, and secondly, the presumption is that records are turned over. Any exceptions to those rules ought to be narrowly construed. Thirdly, I'd like to say that I do think there's a role for the Attorney General in proposing legislation. With this is the second most powerful job in Kentucky state government. With it comes the bully pulpit, to be a consumer advocate, an advocate for open records, and if legislation needs to be proposed, I'm the type of candidate that can work with the General Assembly to get legislation passed. An area I would